Now, the latest Fairfax Nielsen poll suggests the government's proposed change to the Racial Discrimination Act looks to be rather unpopular with voters.
9 out of 10 respondents say they believe it should remain unlawful to offend, insult or humiliate somebody else based on their race. To discuss the results, we're joined in Sydney by the Race Discrimination Commissioner, Tim Soutphommasane. Tim, good morning to you.
Good morning, Michael.
Were you surprised at the extent to the opposition to these proposed changes revealed in the Nielsen poll?
No, I think there's a resounding statement here of Australia's commitment to racial tolerance. People see no need to be changing laws that have been in place for almost 20 years and have worked well. It's important that we have laws which reflect our commitment to values of civility, decency and racial tolerance, and that's what we're seeing through this poll today.
Do you believe it's the case of the government not adequately explaining to people what is wrong, if anything, with the current legislative framework?
Well, it's not clear what the problem is. These laws were introduced in the 1990s as a result of a number of major inquiries and reports, including a Royal Commission into Aboriginal deaths in custody, including a national inquiry into racist violence. There's been no equivalent report or inquiry of that gravity that has preceded the release of this exposure draft into amending the Racial Discrimination Act. The only reason we have been given by the government is the Andrew Bolt case.
And that really hasn't stood up in the eyes of many experts.
No, and it's clear from the Andrew Bolt case that he breached the law as it currently stands, and he couldn't enjoy the protection of free speech that is contained in the Racial Discrimination Act, because in his articles about fair-skinned Aboriginal people, he combined errors of fact, distortions of the truth, and used inflammatory and provocative language. The protection for free speech that currently exists requires you to act reasonably and in good faith, and he didn't act in that way. And the question to be asking, I believe, with proposed changes is, what exactly do you want to say that isn't currently protected by Section 18D of the Racial Discrimination Act?
There are also lots of concern about what many people saw as the limited nature of the changes. In particular, the prohibition on intimidation was, under the proposals put forward by the Attorney-General, restricted to physical violence. That, in many people's eyes, was simply far too narrow. Do you agree with that?
Yes, I do, and there are a number of problems with the exposure draft that was released by the government last month. As you say, there is a very narrow definition of what intimidate involves, also a very narrow definition of what vilify means. Vilify is not defined in its ordinary meaning, namely speech that degrades or denigrates, but in terms of the incitement of racial hatred on the part of a third party or public audience. But the biggest deficiency with the exposure draft is the broad category of exception that is provided for anything that is done in the course of public discussion. What this exception does is it removes the requirements of reasonableness and good faith, and it means that you can be acting unreasonably, in bad faith, dishonestly, but so long as it's connected in some way to public discussion of a political, social or cultural issue, then it's to be protected as free speech. And what that does is it obliterates the dividing line we currently have between free speech and hate speech.
How much of the result we're seeing in the Nielsen poll today, do you believe, Tim, is the result of what Fairfax is describing as that political own goal of George Brandis saying people have the right to be bigots?
I have no doubt that people are very concerned about the fact that these proposed changes have been justified in terms of expanding the freedom that people should have to be bigots, for the simple reason that any right to be a bigot should not outweigh the right that everyone should enjoy to be free from the effects of bigotry.
And finally, do you expect now these changes are essentially dead on arrival?
Well, I call on the government to heed the public concern that's been expressed, and it has been expressed for many months now. We've had more than 200 organisations from multicultural and ethnic communities and from civil society at large expressing their concern about proposed changes and about the need to retain current protections against racism. I call on the government to abandon their move to change the Racial Discrimination Act. There's just no need for it.
Tim Soutphommasane, thank you very much for your time this morning.
My pleasure. Thank you, Michael.